Hello, and good afternoon. My name is Ellen Krug. I'm the Executive Director of Call for Justice. It's a very small nonprofit in Minneapolis that has a big job. We work to connect low income and moderate income people with civil legal resources in the Twin Cities and in greater Minnesota. Part of our work, part of our project is to help train United Way 211 in the associated with Greater Twin Cities United Way on how to make targeted legal referrals. And as part of our training sessions and training program, we are here today to talk about civil commitments. We have two of the most well-known and experienced attorneys in the state of Minnesota to help guide us through the civil commitment process in Minnesota. Our speakers are, on my far right, Pat Olson, who started with Hennepin County as a welfare worker in 1990, moved through various jobs at the county, went to night school, and eventually became an assistant Hennepin County attorney in 2001. She was assigned to family court from 2001 to 2008, and then transferred to the Hennepin County Attorney's Office Adult Services Division to work on civil commitments through mental health court. To my immediate right is Andrea Martin, who graduated from the University of Minnesota Law School in 2005. During most of her law school career, she worked as a law clerk in the Child Protection Division of the Hennepin County Attorney's Office. After law school, she worked with Judge Robert Blazer as a law clerk in Hennepin County District Court, working on civil and criminal cases. In 2007, she rejoined the Hennepin County Attorney's Office as an attorney and has been serving in adult services, the Adult Services Division of that office ever since. Please help me welcome Pat and Andrea Martin.
Thank you guys, for having us here to talk about civil commitment today. Ellie asked us to give you guys an overview of the civil commitment process in Minnesota. And I should start with a caveat that our experience has been exclusively in Hennepin County. And although the civil commitment law applies uniformly to the entire state, each county applies things a little differently. And so our experience has been, and what we'll be talking about today, is primarily what happens in Hennepin. When we're aware that something happens differently in other counties, we'll make note of that for you. Today we're going to talk about the commitment background, essentially what is it, the criteria for commitment, who qualifies for civil commitment in Hennepin County, the commitment process, so what happens when commitment is necessary and how that plays out from the very beginning through court and after commitment, and then tips and resources for your information and referral specialists, the people that are answering the phone, answering questions from the community about this topic. So the first thing we're going to start with is, what is commitment? I think there is a lot of confusion in our society about what civil commitment is. And in its most simple form, what civil commitment is a court order for the treatment of a mental illness or a chemical dependency. And if you'll notice on the PowerPoint, I put a little asterisk next to that. And that's because in Minnesota, there are some other forms of civil commitment as well. But truly, those are more rare. And usually, treatment professionals are involved from the get-go in those. And so we're not going to be addressing that. There are things that you probably have read about a lot in the news lately, like commitment of sexually dangerous people or the sexual psychopathic personality people, the people who are committed as mentally ill and dangerous to the Minnesota Security Hospital, and I think people committed as developmentally disabled. Those kind of topics have appeared in the news a lot lately, but we're not talking about that because most of commitment petitions in Minnesota are not dealing with those people, and those probably are not going to be the calls that you're going to be getting. So who qualifies for civil commitment as mentally ill or chemically dependent? Here are the basic elements of the things that we would need to show in order for somebody to be committed either as a mentally ill person or a chemically dependent person. And when we're asking for somebody to be committed as mentally ill or chemically dependent, we have to designate that allegation up front. So either we're asking for commitment as mentally ill or we're asking for commitment as chemically dependent. We can also ask for both, As you guys might imagine, there's a lot of people that suffer from both things, mental health conditions as well as addictions. And so they have to have a mental illness that's been diagnosed if we're looking at a mental illness commitment. If we're looking at a chemical dependency commitment, what we have to be able to show is that this person has been excessively and habitually using drugs or alcohol. Because of the condition that they've been diagnosed with, we also have to show that there's a substantial likelihood of physical harm to themselves or to other people. And there are several ways that we can show that to the court. We can show that because of their condition, they're failing to provide themselves a major necessity. So like clothing, food, shelter, medical care. And that would go for either a mental health commitment or a chemical dependency commitment. We can also show that because of their condition, they've recently threatened or attempted to hurt themselves or somebody else. So for that condition, we would be showing, say, somebody was engaging in suicidal behavior. They took a bottle of pills, they were cutting, they tried to assault a friend, a neighbor, a stranger, somebody, or they've threatened to do those things, and that threat that they've made seems very real, that they would actually carry it out. If we're looking at a chemical dependency commitment, we can also show that because of their use, they've had recent serious physical problems. So for instance, a person suffering from alcoholism might have a hepatic liver. They're starting to show signs of that. Their skin is jaundiced. Perhaps they've been admitted to the hospital intubated because they've been so intoxicated they can't breathe for themselves anymore. All of those things would be ways that we could show that because of their condition, they're a harm to themselves or others. And finally, and I think most importantly, which cuts a lot of people out of this seemingly large group, is that this has to be the least restrictive way for them to get the treatment that they need. So if a person is at the hospital and they're saying, well, I'll take my medications and I'll stay here, or I'll do enough of this to keep myself safe, they don't qualify for commitment, and that's not something that we can pursue. And finally, there is no age requirement. And so fortunately, we've got Pat with us, who actually in our office is our juvenile expert.
We don't do a lot of juvenile commitments because in general, if a juvenile needs help, whether it's mental illness or chemical dependency, the parental authority is enough. The parents can consent for them, they can authorize various treatments, they can admit them to hospitals or treatment programs, and so that deals with almost all of them. When that doesn't work, then it's usually juvenile court, either the child protection arm or the delinquency arm does it. It's only when, for some reason, neither of those resources will work to authorize the treatment, then we do it through commitment court. And there is no minimum age, but I think in the history of Hennepin County since 1857, there's been one 13-year-old. It's almost always 16 and 17-year-olds, very few of them, but there's always a little trickle, you know, where the parental authority in juvenile court isn't going to do what they need. And so periodically we get them, but it's pretty rare.
So here are the basic steps of the process of getting somebody committed. The first step would be a hold, and that would be the process of getting a person from where they are in the community to somewhere where they can be evaluated and assessed for their treatment needs. And then the next step would be actually initiating the petition itself. And then there is an agency that exists in every single county in Minnesota. It's called the Pre-Petition Screening Program. Sometimes it's just a small group of people who work in a county's Health and Human Services department, but every county has one, and they do an initial review of whether a person meets commitment criteria. Then there's the court process itself, and finally the judge's decision, the court order, and what that means going forward. For an initial hold, let's say we have somebody who's starting in the community, and I would imagine that that's where a lot of your calls would originate. Somebody's at home with their parents and they're not doing well, and parents call you, oh my gosh, what do I do to get my son or daughter help? there's essentially 3 ways that a person can be ordered from where they are in the community to a hospital. And usually it's the police, or there's another agency, at least in Hennepin and Ramsey. I can't speak to the other counties, but at least Hennepin and Ramsey have crisis outreach for people with mental health problems. In Hennepin County, it's called COPE, the Community Outreach for Psychiatric Emergencies, and I know Ramsey has a counterpart. They come out, they evaluate a person, and then if they believe that the person is posing a danger to themselves or others, they can say to the police or an ambulance, please take them to the hospital. They have the authority to pluck that person out of the community and take them to the hospital. Another way that it can get done is I believe a doctor can also issue a request for the police or ambulance to take a person in. I would say that happens a lot less frequently. Most of the time, the cases that we're seeing, it's the police responding to an incident or COPE responding to an incident. Once the person is at the hospital has to decide whether to keep the person for evaluation. And again, they're going to look at whether a person is posing a danger to themselves or others if they're not at the hospital. That hold lasts truly for 72 hours. That ends at 72 hours. If nothing has been done, they have to be released at the end of that 72 hours. The treatment staff at the hospital have the exclusive authority to decide whether that 72-hour hold is placed and whether it ends prematurely. I know yesterday we had some questions about whether doctors can just end it, say after 24 or 30 hours. And absolutely, if that doctor placed that hold and they believed it was necessary, they also, after a period of evaluation, can decide that it's no longer appropriate and that they can end it. And that there are some reasons for that. First of all, if a person says that they're going to be cooperative, there's no need for it anymore. And for us, it's actually better because it gives the person an opportunity to show whether they are able to follow through with the recommendations that the treatment team is making. And also there's a prohibition in the law against placing back-to-back 72-hour holds. So what that means is, say your hold started at 10 a.m. and at the end of those 72 hours, they're like, oops, we should have done something. We're going to start another one at 10 a.m. 3 days later. Can't do it. And so if the doctor ends it after 24 hours, the person is cooperating, and then decides, no, I'm not going to do this anymore. They can place a new one then because they've been off the hold for a period of time. So there's a couple of reasons why a doctor might end it early.
And yesterday we talked about whether there was actually an official document that's a hold, and could you explain what a hold actually in paperwork looks like?
Right, and they're on a transport hold. Usually what we see in the medical record is just a really basic form, either from the police or from COPE, that says why this person is being transported to the hospital and the signature and badge number of the officer who decided to place that hold. It doesn't provide a lot of information to the hospital. What have you seen on some of those?
I have seen some that just say AMS, and that's short for altered mental status, unable to care for self, or something like that. The transport hold just lasts long enough to get the person into the hands and assessed by a medical, an MD or an RN at a hospital. And so that could be for 5 minutes if the police get somebody across the street from a hospital and just walk them across the street. Or if there's a blizzard and a traffic jam, it can last for hours while they're trying to get the person to the hospital. Then the 72-hour hold she's been talking about, that's got to do with the medical hold. But that's part of, to protect the person, is different people look at the same person and look at the same behavior and what's going on. So nobody has absolute authority to put a hold on you and just keep you somewhere for a long time. The authority keeps being double-checked by others. So.
And I think one of the other things that's important to note about that is that if a family member is with this person in crisis and says to the police, these are all the things that have been happening, that doesn't necessarily get communicated to the people who are at the hospital. And so one of the things we talked about yesterday was how important it is that whoever believes that they have a lot of information about this person's condition and their need for treatment, that they end up talking directly to the staff at the hospital and don't think that because they've told this police officer or told COPE that all of this is getting communicated to the staff at the hospital, because honestly, often it is not. And so the people at the hospital need as much information as they possibly can get to decide whether to place that 72-hour hold. I mean, often somebody is in the community and because of their illness and in the environment that they're in, they're acting one way and they get to the hospital and they look pretty good. And the hospital—
They seem just fine.
Yep, they look just fine because they're able to hold it together. I mean, any of us know that even when we're just, say, grieving or have stressful situations, if we have to, we can put on a pretty happy face and look pretty good for a little bit. But the hospital doesn't know about this background, and so it's important that people with collateral information get that information to the treatment staff to help them make decisions. I know yesterday one of the questions was, well, callers call in and they say that they've called COPE and they say that they've called the police and they get to the hospital and the hospital doesn't do anything. Well, it could be that the hospital doesn't know what has happened.
I've got a quick one. So
Yeah.
you mentioned that there's no back-to-back holds. Is there like an official cool down that has to happen then? Is it like 1 hour? Does it have to be a full day or?
You know, it could be new behavior. You could be the doctor and remove the hold and everything is fine for 10 minutes and suddenly, really unexpectedly, the person punches an RN. That we would argue anyway, and there, I don't think there isn't an appeals case that gives us, well, this is the test of what constitutes enough new behavior. But if it's pretty extreme, like punching a nurse, you know, I think the hospital staff would feel pretty confident about placing another hold because that's a new situation. You know, if it's 4 days later, you know, that's definitely not consecutive holds. So it's, you know, it needs to be in good faith, but we don't have a specific rule about that.
Sorry.
I was going to say, and ultimately at the end, the hospital staff needs to talk to their internal lawyers about whether, if they have a question, whether it constitutes a back-to-back hold. And in the end, it's up to them, that internal counsel, to decide which fight do they want to fight. If they really think that this person is a danger to other people, do they want to fight the lawsuit that they improperly released this person? Or do they want to fight the fight that they improperly held this person? And it's up to that counsel.
And I was gonna stress that what Andrea said about telling callers, you know, you're getting callers in panic mode, but based on their call to you, they may be formulating a game plan on how to deal with whatever the situation is. I mean, obviously, if the situation is extremely urgent, you know, your advice is call 911. But I think regardless of whether the advice is 911 or whether it is to call COPE or whether it's to call something else, I think Andrea's advice is crucial about being able to say to the caller, make sure that you follow them to the hospital, make sure that you go to the hospital, you bring whatever records that you have about this person at home, you hopefully have written down or do write down all prior providers, because if they go through the commitment process, and I'm getting a little ahead of them, but part of that is grabbing all the medical records for what this person is. So I think that is crucial advice that you can give to the callers. Hold on a second, before we're done with the call, I want to make sure that you know that it's important that you do this, okay?
I had an interesting call the other day, and the person who was calling was not a relative, but was someone who lived in the same apartment complex, and a group of other residents together at different times had been witnessing some very disturbing behavior, like crawling in the ceiling vents over other people's apartments, but they hadn't really connected a big story together. Would the hospital be willing to maybe take a statement from a group if they all work together to write stuff down? They're not family members, they don't know the medical history.
They could, you know, the hospital is, in order to treat people, even if they're not looking at whether to put a hold on someone or not, but in order to treat somebody, whatever information they can get that seems reliable, So if family members come in and they're telling different stories and each one is telling the doctors the other one is lying, then the doctors are going to be very careful about that. But other than that, if someone comes in and says, I'm the next door neighbor and this is what I'm aware of, and then plus these other neighbors are also very concerned, and if that person wants to bring in a letter, or something like that, whatever form it's in, the doctors can take in any information that seems reliable and they can start making some treatment decisions on that. They continually reassess what they're doing, and so the next day, sometimes they start out treating somebody and then they realize that some of the information they got is accurate and some of it wasn't, and they adjust what they're doing, and they look for symptoms in the hospital and go, okay, based on what I'm hearing they did in the community, is what they're saying and how they're looking, is that kind of consistent with somebody who maybe just did this? And it's very dynamic and stuff, but they'll take in any information they can. They can't give out information.
But they'll take it.
But they'll take it in. And so, it's not like it had to be in a certain form or like everybody would have to show up and tell the doctor directly.
Okay.
Doctors have a lot more freedom than courts do as far as hearsay. It's, and often when family or friends bring somebody in, the first thing the doctors do is say, thank you for bringing her in. What's going on? What's your relationship? What are you concerned about? What did you see? And also, are there any other hospitals this person has been to recently?
And my quick response would be, it takes a village.
Yeah.
It really does.
Yeah.
So, I think that you get that kind of a call, you encourage them to collaborate and convey information one way or another to the treating facility.
Right.
Yeah.
The one thing that I would comment too is if, say, one person acts as a point person to contact the police or COPE, for instance, that we still have the names of the people who observed the behavior when. And the reason that I say that is when we file a petition, one of the things that we need to be sure is in the petition is if there's any particular behaviors that we're saying meet those criteria we talked about before, we have to have a name associated and when they observed it. So if they say that all this stuff happened, but in the end we're not able to substantiate it or prove it in court, it kind of doesn't matter.
Yeah. Vague things like, has killed a neighbor's dog. Well,
Or
okay,
neighbor.
whose dog, how do you know they killed it? That kind of thing we have to dig up later. A doctor can start treating based on, mother brings, the son in and says, he's killed the neighbor's dog and I'm worried he's paranoid. They can start treatment and work on that. But when we're in court, we can't say he killed a neighbor's dog unless we can say, whose dog and how do we know he killed the dog and what date.
Sure.
The final thing that I was going to say about this hold issue is that, at least in Hennepin County, the hold, whether there is a hold on a person, affects the timeline of a case. So some people who go to the hospital aren't put on hold. They're saying that they'll stay. Perhaps they'll stay, but they won't take the medications. But the doctors then won't put a hold on them because they're happy to stay there. Let's say that they're homeless and they have no place else to go, and they're perfectly happy staying in the hospital where they have a warm bed to sleep in and food, but they just don't want the treatment that the hospital is providing. They might not place a hold. It could be that later this person changes their mind and wants to leave, and later a hold will be placed. But when there is a hold, court is going to happen essentially 6 days after that hold is placed. If it's not there, the court might push it out because there's not urgency under the statute for that to happen. During that 72 hours, if a person's on hold, the hospital needs to decide whether to initiate a petition. And that's why that 72 hours is a huge time crunch. They can't decide at hour 65, oh my goodness, now we need a petition. They need to decide up front because there's a lot of things that need to happen, which is another reason that our advice is to make sure that hospital gets all the information up front as quickly as possible so that they can decide whether a petition is going to be necessary. The person or entity who's asking for the commitment is called the petitioner. In Hennepin County, it's almost always a treatment professional or a treatment facility. almost always.
Doctor, RN, psychologist, like that.
Yep, social worker is the petitioner occasionally. And there has to be a doctor or a psychologist or a nurse or a physician's assistant who is willing to say in writing, this is the diagnosis that this person has, whether it is a mental health condition or an addiction. This is the kind of treatment that they need and that they need to be committed. So every single petition, in order for it to even be forwarded on to the next step, needs to have a doctor who has seen this person and who is willing to say that. If that doesn't happen, it's very unlikely that we can go ahead with anything.
And that's before it even gets to pre-petition screening.
Right. Yep. And they need to have detailed information as to why commitment is appropriate. And that's where that, Jennifer, that question where you had raised about whether, one neighbor can say something or you need a statement from everybody, this is kind of where that more detailed information comes into play, because that's the kind of information we would need to include in the petition.
At the list that you've given for people who can recommend commitment, these all look like prescribing level professionals. Can a mid-level professional, like a marriage and family therapist, do this? No.
No, it has to be a
Okay.
licensed practicing psychologist.
They don't have to be able to prescribe medication, but a licensed psychologist is.
Or a nurse practitioner, or a
Yeah.
PA, or.
Right,
okay.
exactly. Yep.
But if they think, if you've got a lower level LCSW, somebody that is treating a person, they've got professional requirements, professional ethics that require that if they believe somebody has a need to be committed, they've got their own professional standards that gets them to point B and C with that patient.
Chances are they would be calling for help, either 911 or COPE, or bringing the person to the hospital or something, because, a need for commitment means there is a physical danger to the person or someone else. So, they would be trying to get them to those professionals anyway who do the assessments.
Yep. And so once a treatment team has decided that a petition is appropriate, and they've got that statement from the doctor, psychologist, whomever, the next thing they do is they call pre-petition screening. And like I mentioned, every single county has a pre-petition screening unit or program. And their purpose really is to review the request for commitment. They're going to look at the person's medical records. They're going to talk to that person. They're going to talk to the hospital staff. They're going to talk to any sort of collateral person who might have information, if that's family, if that's friends, social workers, probation, whoever might have that kind of information. And they look at the diagnosis and they compare all these things, the history, what people are saying, how this person is presenting, and they decide, do we think that this person really meets commitment criteria? They sit down, usually in a group of how many, Pat, like 3 to 5?
Usually, yeah.
3 to
around
5 of
3 or
them.
4.
At least in Hennepin, and they talk about the information they've collected, and they decide as a group, is this something that we can support and say, yes, commitment is appropriate, or no, we don't support commitment for this person. Most of the time, I would say that if pre-petition screening does not support commitment, the hospital just says, okay, and that 72-hour hold will expire and the person will be released, and that's the end of it.
And our office never sees it, never hears about the person at all. The statute actually requires the pre-petition screening. The idea is they're supposed to disagree some of the time with the professionals at the hospital. That is their job, is as an independent second opinion sort of in there. So sometimes they agree, sometimes they don't. If they don't agree, sometimes the hospital says, fine.
And they are people who are skilled in working with people with mental illness or other addictions. They are social workers, nurses, psychologists, and most of them come from backgrounds where they've actually been in a treatment setting. And so they have worked directly with people with those conditions, and they know a lot about conditions and whether people meet legal criteria for commitment. If the decision is to support the commitment, they write a confidential report summarizing all the information. They'll summarize the medical records they've reviewed. They'll summarize the history, what was said during the interview, with the respondent as well as with any other collateral people, and they'll tell us at the end of the report why they're supporting the commitment. If the decision is to not support, what they need to tell that person, the petitioner who's asking for the petition, is that they have a right to appeal it to the county attorney's office, and that the county attorney can look at all the information and decide whether to file it, even though pre-petition screening says no. We usually get a very brief report at that point, and we need to investigate ourselves to decide whether to file. And mind you, this is all happening during that 72-hour hold, because I need to file that petition usually at least an hour before that 72 hours ends. Otherwise, the person is released.
And most 72-hour holds that are placed by medical professionals, the vast majority of them, they never file a petition. That's not the point. They want the person to not leave right now. They're working with them. Things are getting better. And the person is going to be calmed down, and by the end of 72 hours, everything's going to be fine. So when they put that 72-hour hold on, they don't know that they're going to file a petition. It's only if 12 hours into it, they're thinking, gee, this person is just not going to get better within 72 hours, and I have no choice but to file a petition. So they're already, at that point, then there's a bunch of work. They have to have their staff at the hospital write up a bunch of stuff. Then that's got to go to pre-petition. Pre-petition needs a day or two because they've got petitions coming into them from all over, so it goes in line. So they scramble to collect as much information as they can. If there's an appeal, someone in my office usually has about 20 minutes to decide. And most of the people we call, we get their voicemail. So it's very, it's a very tight schedule. And by the way, the appealing, we don't pretend to have any kind of clinical training or anything like that. It's not really an appeal of their decision. You have hospital staff, MDs, who said, yes, this meets commitment criteria. Then you have another group of professionals who says, no, it doesn't. So the clinical opinions are opposing each other. We just look at it from an evidence standpoint. What do we have? What can I present? Do I think I have enough that I have a chance of, the judge saying yes on commitment? And so we're making a legal determination. We're not pretending like we know more than the professionals.
And I think that's a question that came up yesterday is, how much do we need to prove? And from what I understand, you guys have had training on the civil burden of proof, preponderance of the evidence. It just has to be just a little bit more than sure that you're 51% certain that this is the right thing. Criminal, beyond a reasonable doubt, like this is the way it is. We're somewhere in the middle, clear and convincing evidence. So we have to be we have to show the court that it's pretty darn sure that they meet those criteria we talked about. And so that's what we're looking at when we review the non-support. And so to hammer home that same point that we made initially, that the information from the community members needs to get to the hospital, that's how pre-petition screening learns about collateral information that might be important to their decision whether to support or not. And they will call those family members and say, tell me what happened, tell me what you know. But if they don't know that this person has information, and usually they get that from the hospital, they're never going to know to call them. Pre-petition screening does not go on a fishing expedition. It's not like CSI where there's police officers out there scouring the world looking for additional information about this person. They'll look at the information they have, but they're not going to go looking for more.
Yeah.
So after we decide to file a petition, we've reviewed it for legal sufficiency, we sign it, we file it with the court. The county attorney, our office, is the lawyer for the petitioner, lawyer for that facility that's asking for the commitment, or the doctor, whoever is asking for it. The court is going to appoint an attorney for every single respondent. The respondent is the patient who we're asking commitment for, and they're going to do that regardless of whether that person can pay or not. And so that's really different than the criminal side, where there's that threshold of income to a point. I've had several people who are millionaires who have had court-appointed counsel in the civil commitment process. And that attorney is their attorney throughout the entire commitment period. That person can decide to fire this person and hire their own if that's really what they want to do. And occasionally people do that, completely up to them. But everybody gets one, and there's a panel, and it's actually the Hennepin County Bar Association in Hennepin that maintains a roster of people who have other practices. They're all regular civil attorneys or sometimes criminal defense attorneys who have their own private practice, but then they take on these assignments as the court appoints them as well. And I think in our county, maybe 30.
Yeah. And they have training in mental health law, and they're familiar with mental health court, with probate court. So that's one of the reasons why you get an appointed attorney, is so that you get a good one, because our process is so compressed in time, and it's very short period of time to make sure nobody's deprived of treatment that they need, but also so that if somebody doesn't meet commitment criteria, they can talk to a judge and get it dismissed and get out of there as quickly as possible. So it's for the person's benefit, but nobody can hire a competent attorney in that short period of time, especially not in a very specialty area of law. So that's really to make sure they get a quality attorney.
The other thing that happens upon filing the petition is usually, if the person is on a 72-hour hold at the time we filed, the court issues another hold, extending that 72-hour hold for another 72 hours until a preliminary hearing can happen. In Hennepin, we also do our examination at the same time as a preliminary hearing. And what an examination is the court appoints another psychologist, their own psychologist or their own psychiatrist, to meet with this person and come up with a recommendation. In Hennepin, we do that on the same day as our preliminary hearing, just to expedite things. I know other counties handle that very differently, depending on where they are and how their process works, the timing of that examination. But the preliminary hearing does have to happen within 72 hours from the time the court issues that court hold. So at that point, the person will be on hold for about 6 days. And weekends are excluded from those 72 hours, as well as legal holidays. In Hennepin, we then have a trial 3 days after the preliminary hearing, usually 3. I know other counties, again, do that a little bit differently. But usually it's 3 unless there is a benefit to the respondent to extend that longer, or some massive scheduling conflict for the court or the parties.
Can I just jump in here and just say that, recall that when we did the criminal law training, there were certain due process, certain procedures that have to be followed in a criminal case because there's the issue about loss of liberty. Way different than just a civil case where just money is involved. And so these procedures that Andrea and Pat are talking about are procedures designed to help comply with due process, particularly the appointment of a lawyer. It is the lawyer is there to protect somebody from losing their liberty without due process. And I just, the further backdrop on this is that, there is a misconception that if somebody gets involved with the commitment process, that it's a one-sided deal, that it's a railroad, that, that somebody can get lost in the system. What we're hearing here are multiple checks and balances to protect the rights of the person who is at risk of being committed. It's also to protect the rights of to protect the health of that person as well as the safety of the general public.
Right.
So I just wanted to throw that in. Thanks.
And so at court, at least in Hennepin, we have court appearances on 2 days. First, that examination. And like I mentioned, the court appoints a psychologist or psychiatrist. And what that person does is they review records. Our office will request all the records that we're aware of. So again, this goes back to whoever's in the community communicating about where this person has been. Because if we don't know to request, say the person's at Abbott now, but they had been to HCMC and North Memorial twice within the last 2 months, but nobody tells us. I don't know to request them. And again, I don't cast a fishing net out to every single community hospital looking for records. I have to be pretty certain they're there. And so if I know, I will request them, and it's important so that that psychologist has even more forensic information to look at in deciding what this person suffers from and what kind of treatment they need, and whether they believe this person is going to follow through with treatment in the future. They're going to also interview that patient, and so that they can do their own examination of this person and see whether what they're seeing is consistent with what they're reading in the records, and whether they believe that what the doctors are diagnosing this person with is accurate. And in the end, they make their recommendations in a written report to court. It's usually a really short report, but they're going to give the person a diagnosis if they believe there is one, and then address all of those other factors that we talked about at the beginning. Has this person engaged in something that is harmful to themselves or others? And do they believe that commitment is necessary? Or can there be something else that's less restrictive than the court saying you are going to treatment?
And by the time they see the person, that person might be doing an awful lot better, because it's a super dynamic process. There was a crisis in the community. It looked absolutely terrible. By the time the person has been in the hospital for a while, by the time we get to the preliminary hearing, people are usually doing much better than they were before. And then 3 days later, if we come back on the day of trial, and the doctors at the hospital are constantly reassessing too. And if they realize that really commitment is not needed, at any point they can call us and say, we'd like to dismiss our petition. And they're supposed to do that if things are getting better. Sometimes they just needed some more time with the person. So it's a very dynamic thing, and each professional is seeing the person at a different time, and the person tends to be getting better and better and better.
And so that's one of the things that can happen at that first day in court is a preliminary hearing. We might have a chance to end the case with an agreement right then and there. The patient or respondent can agree to stay in the hospital and say, I'm just going to stay here until trial. I don't really need a hearing today. Or else they can say, I'm not staying here one more day. I want a chance to tell a judge, release me, get me out of here. I don't want this. And that's their right, and we have a hearing. Where we go into court, we present evidence, usually medical records or other reports. Occasionally we'll ask for additional testimony from a doctor or that court psychologist who just interviewed the person. And that person has a chance to tell the judge, no, please release me. And what we would have to show then is that there's a risk of serious physical harm if this person is released prior to trial. So in those few days in between the time of the preliminary hearing and the trial that's set for a couple days later. Then when we finally go to trial, whether the person is still at the hospital or not, most cases settle without a trial, usually at that preliminary hearing or on that day of trial. I would estimate 75% of our cases settle for something less than commitment. And people asked some questions what that means yesterday. And if you kind of think about what probation is in the criminal sense, so you're not in jail or prison, but there's certain conditions that you have to comply by, that's kind of what our agreements are. It's not really considered probation, the person's not in trouble, but we're saying these are the treatment things that you need to do for the court not to order you to stay at the hospital or in a chemical dependency treatment program. And it could be that the condition is, I'm going to just agree to voluntarily stay in the hospital. I'm going to agree to take my medications. I'm going to agree to go to a private inpatient chemical dependency treatment facility, and I'm not going to use the drugs or alcohol that was causing this problem for me. And then they would be still back accountable to the court. If there isn't a settlement, though, if we can't reach an agreement, if the person is saying, no, I don't need this, you people don't understand, this is not my problem, and the things that people are saying about me are lies, they have a right to have a trial. And each party has a chance to present evidence to the court. Our office usually presents their medical records in the very least, and often also has a doctor from the treatment facility testify, usually by phone, about their diagnosis and why they believe the treatment is necessary. And occasionally we also have people from the community testify about the things they have seen or heard. If the allegation is that this person assaulted their neighbor, and the respondent is saying, if that never happened, that person is a liar, we would probably ask the neighbor to come in to testify, because the court's going to want to know or have an opportunity to say how credible is each person's statement. Does it seem like the neighbor is telling the truth, or does it seem like that respondent is telling the truth?
Although we do try and keep our hearings as, they are relatively short. I'd say most of them are about an hour. So it's not the 3-week, it's not the O.J. Simpson kind of thing. But one
These
of
guys are too young for O.J. Simpson.
dated myself. But one thing is, a lot of times it's the family that got assaulted. It's the family that brought the person to the hospital. They're the ones that are very concerned. They're also going to be that person's family and loved ones for the rest of their lives. And somebody in crisis going through this, a lot of times will be very angry at the family, and they will blame them. And so if the person is doing really well in the hospital and we don't have a lot of evidence through medical records, we might need a family member to come in and testify. But on the other hand, if we have enough evidence from medical records, then we can usually avoid that, and then the family member decides based on their relationship and what's going on, are they going to come to court at all, or are they going to stay away? Or if they come to court, sometimes they'll just come and sit there, and we introduce them as, so-and-so's family is here to support him today. And that works especially well when half the family wants a commitment and the other half doesn't. They're just here to support him today. And they don't have to fight. They don't have to testify against each other. They don't have to, have their relationship damaged. We do that whenever we can, but that goes back to, did you tell the hospital? What other hospitals have they been at? Has there been police calls? What dates? What cities? So that we can get police reports, we can get COPE reports, we can get the records from the other hospitals. The more information we have in documentary form, for one thing, in the hearing, we're not rubbing that in the person's face, and we're just not trying to punish them. We just want to give them the treatment, so we don't want to embarrass them or upset them. So it's nice if it can go in document form, and also that spares their loved ones from having that conflict. So,
if a settlement is reached, are one of the professionals involved assigned to oversee the behavior? So if the respondent violates the terms of the agreement, it's reported?
Exactly, yep. Actually, what the law is that every county designate an agency that is responsible back to the court. So here in Hennepin County, it's our Health and Human Services Department. They assign a case manager who will look at all those conditions, and there is varying involvement depending on who's assigned. The most basic, and we'll go over this a little bit more later, but the most basic form of case management, the case manager meets with the person at least once a month, and probably a little bit more as they're getting close to leaving a hospital or a treatment facility, and that they have regular phone contact with the person, and that person has to sign releases, the patient has to sign releases, so that that case manager can call their treatment providers and say, how are things going? And so if that case manager learns that they're in violation of that agreement, they do have the authority to revoke usually whatever agreement that we had, and ask that the person be taken back to the hospital.
And then what stage of the process does the respondent go back to if they violated the terms of the settlement? Is it all the way back to the beginning?
It kind of depends on the form of the settlement, and there's different forms of it. If we, most of the time, most of our agreements are called a stayed order for commitment, and there what the respondent is agreeing to is that they actually meet commitment criteria, but that the court isn't going to commit them right then and there. And so what it says is, I understand that I meet commitment criteria, these are the things I'm going to do, but if I violate it, all the county attorney has to do is send a report to court, and if the court thinks that they have violated based on what's been described by the case manager, they will issue an order for commitment right there. They don't get a hearing again unless they request it, and that's but it's a hearing on the issue of whether they violated. It's not a hearing on the issue of whether they meet commitment.
So the written report usually originates with the case manager, who's a social worker that follows them in the community. That person sends us the written report, and we put a motion on top of it and send it to the court saying, you know, everything is going awry in the community. Not only are they not following the rules, but, you know, there's danger, we're concerned, we think they need hospitalization. The court issues an order saying, okay, now they are committed, and usually orders the sheriffs to go pick them up and take them to a hospital. But what kind of hospital and where they go from there is different depending on the person, what the danger is, what's going wrong, the form of the agreement. We have, you know, different kinds of agreements that we do, things like that. But the case manager is the person who is consistent, because usually at the time the court is done initially, the person is in the hospital. After that, they might go back home to live with relatives, or they might go to a group home for 30 days or 60 days. Then they might go to 90 days of chemical dependency treatment. Then they might go to assisted living, or they might go back to their own house. So over the 6 months, they could change outpatient providers, and they could change where they are quite a bit. There's one person who kind of, you know, is following the whole thing, so the person doesn't get lost and there's some coordination of services, and that's the case manager.
Mm-hmm. And there is one other type of settlement agreement which is considered a continuance for dismissal. We do far fewer of those, and usually I can't say it's a policy, but at least for my practice preference, if I have good evidence now that this person meets commitment criteria, I'm not going to agree to this, because essentially what the court is saying in that kind of order is, I'm not going to make any decision right now. Here are the conditions you need to comply with. If you violate them, then we have to come back and have a whole commitment trial from the very beginning. And, you know, my personal practice preference is that if I have good evidence now, I have people lined up to testify, I have all my records in order, I'm not going to wait 3 months for that to become stale.
Yeah.
So that happens a lot less often, but it's still, my answer to your question is it depends on the type of agreement. As part of the trial, if we do have one, one of the people that would likely testify is that court examiner, that psychologist or psychiatrist that offered the court an independent opinion. At least in Hennepin County, our judge or our referee is the one to usually call that person as a witness and ask them the questions.
Because they're not on the side of the hospital and our office, or on the side of the patient or the respondent. That psychologist works directly for the judge. Mm-hmm. And if there's medical issues involved, we do have some psychiatrist MDs who can do that and work for the judge. So,
our court, at least in Hennepin, never makes a decision at the hearing. I think in my 7 years or 8 years of practicing, I've seen it happen one time where the judge has issued a decision from the bench. They almost always say, I'm taking this under advisement, and that's so that they can review all the records we've given them. I mean, it's amazing in this electronic age how much paper is generated, but we're talking hundreds of pages of medical records usually. And then whatever testimony, that's a lot to consider. So they usually won't decide right then and there. And so the reason I'm telling you that is from the very beginning, when this person is first placed on hold to the time that the judge would issue a decision in Hennepin County, it would usually be about 2 weeks from the time that they're picked up to the time that the court decides. After that final hearing, the court can do one of three things. If we've agreed to something and we've entered a settlement agreement, the court's going to issue an order detailing what our agreement was. And they'll talk about all the conditions that we've agreed to and the form and who's going to be responsible for reporting what, when, that kind of thing. If we take it to trial, the court has two options. One is to commit the person to whatever entities we've asked that the court commit this person to, or the court can dismiss it and say, no, you need to release this person now. They don't meet commitment criteria. You can no longer hold them. It's a binary decision. The judge can't go back and say, well, instead of committing you, I'm going to put you on that state order for commitment. That is not a choice that the judge can make.
And everyone involved knows that the law requires that we go for the least restrictive alternative that will work. And so the doctors at the hospital are aware of that. That's why they're reassessing day after day. Our office knows that, the defense attorney does. And so if a settlement is possible or if a dismissal is appropriate, then that's going to happen before it gets to the judge. It's, so the ones they're deciding, there's just no room to move. And so that really needs to be yes or no.
If the court does order a person for committed, that order is going to be in effect for 6 months, but that doesn't mean being in the hospital for 6 months. And I know that is a very scary prospect for people facing this, but it is important that they understand and that the families involved understand that it's not like jail or prison where 6 months is 6 months and that's what you're going to serve. That's not how this works. The person stays in the treatment setting that they need to be in until they're well enough to move on to something less restrictive. That doesn't mean that the court jurisdiction ends. It just means that they move on to a different treatment setting, a different treatment modality when they're ready to do that. That court order is going to designate which entities or facilities control that treatment. And the court can, and often does, and I think this is true in a lot of counties, order more than one place. And usually it's in the alternative. So let's say somebody starts out on a psychiatric ward at HCMC. The hope would be that HCMC can get this person well and release them to the community as quickly as possible. Often people are released back to the community within days after the commitment order is issued. But then we're also going to say, and the Commissioner of Human Services. So that means that if HCMC gets to a point that they can't get this person well and it's taking a really long time, that they have the authority to transfer the person to a hospital run by the state. I would say that that does not happen for many people anymore. There's a very long waiting list now for people to be transferred to the state facilities, and I think that the state's facilities are really trying to treat their mission as treating people who have very difficult to treat disorders.
It's like Anoka Metro Regional Treatment Center for mental illness, or the Commissioner of Human Services, the state of Minnesota, also owns CD treatment programs, and that they usually have care in their name. So there's like Fergus Care and Wilmer Care.
Right. If the person is ordered committed, they're not voluntary anymore. They don't have much of a voice anymore in saying that they're going to leave. They can say they're going to leave, but the hospital is going to say, sorry, the door's locked and you're not going until we say that you're better. That treatment facility or the place that's been ordered as the site of commitment, so let's pretend it's HCMC and the Commissioner of Human Services and the person is at HCMC. HCMC has complete authority to determine when that person is better and time to move on. The court doesn't say how a person's treatment, how the person's condition must be treated. It essentially says to that facility, you have the power to keep treating this person against their will, but they're not going to say, well, and you have to give them this medication, and I want you to do individual therapy with them, and I also would like you to get them in to see a family counselor with their family. Not going to do it. And unfortunately, I know often that's what families would like to have happen. I can't tell you how many times I've had conversations with moms or dads or sons and daughters who are concerned about their parents saying, well, they've been to the hospital before and they've taken their medications, but that's not what they need. They need to go to therapy and nobody is making them do that. So this court needs to tell them to do that. I can't do that. That's not a choice.
The judges are just deciding who gets to make the treatment decisions. They're not deciding what that will be. So the court orders never say they must go to 90 days of chemical dependency treatment or they must participate in DBT. No, that's going to be constantly assessed by the professionals that are dealing with them.
And I think, Pat, yesterday you made a good point, which is, in the end, I don't think you guys want the court making that kind of decision. The court has been legally trained, like we've been legally trained. They haven't been trained specifically to make treatment recommendations.
Yeah, and no one can predict for the people also, because people get surprisingly better, or new things are discovered. They fix what's causing the current crisis, and then they discover there's something else that needs to be treated. You know, or they don't get well as soon as somebody thought they would, or they have a setback, and so that it's going to be someone in the community 3 months from now looking at what does that person need 3 months from now.
I have a question about people with severe persistent mental illnesses. So let's say that somebody understands, like they're in a stable place, they're in a competent place, but they understand it's probably not going to be like that forever. They have periodic relapses. Is there a way to go around the commitment process while they're stable by designating a relative or somebody to have guardianship if they were to meet commitment criteria?
There's an advance directive that is really a great idea, and most people's, you can go to, I think it's the Attorney General's website and actually just print it off. And I believe there's 2 versions. One is the version that they actually would like to see everybody do, and it's in the event of a medical thing. If we can't speak for ourselves, what do we believe about end-of-life issues and that kind of thing? And they really want absolutely everybody to fill that out. You can also add, there's a thing called a psychiatric addendum for people who think, you know, my mother had bipolar disorder, I'm getting to the age where it kicked in on her, or I know that I've got an early diagnosis of dementia, I'm fine now, but I might not be, or something like that. Or, you know, anybody who wants to can add that psychiatric addendum saying, you know, this is how I feel about neuroleptic meds, this is any religious things that I have going on about certain treatments, this is how I feel about ECT. And that's a wonderful thing. It doesn't do any good if you fill it out and put it in a drawer. You need to give it to your doctors, and if you name someone in there as an alternate decision maker, it means if you can't speak for yourself, and that's either, you know, you can't speak at all, or everything you say is about blueberry ice cream, and it's just not, you know, answering the questions at all, then you can designate a friend or relative, and I think you can designate more than one. But if their contact information changes, you need to update that. You need to give it to your doctors. You need to give it to the friend, because if they show up at the hospital and say one of these exists, no one's going to believe them unless they have a copy. So that's a very useful thing to do, yeah.
Thank you.
Guardianship is a process as well. Say if a family member understands that commitment meets the short-term needs for this person, but for long-term, this person who is seriously and persistently mentally ill is going to need additional people to be making decisions for them. That's something that the family would have to pursue independently of commitment. And occasionally, even if a person has a guardian, commitment still needs to be pursued. And that's because of the next thing that we're going to talk about just very briefly, which is medications. Even if a person has a guardian, most basic guardianships don't allow that guardian to consent to forced administration of neuroleptic medications. Neuroleptics are a specific class of antipsychotic drugs. They're the kind of drugs that you probably have seen a lot of advertisements for during daytime TV, like Risperdal, Haldol, Abilify, Zyprexa, those kinds of things. And so even if a person has a guardian can't say, go ahead, force that on them, even though they don't want to. There actually is United States Supreme Court law saying that these kind of drugs, people have special protections against being forced to take those drugs. And so they need to have a hearing. And in Minnesota, the only way that you have a hearing on that issue is if you're committed. I know some counties can add that as a special thing under the guardianship, but it doesn't happen very often. And so usually we file that as a separate petition, usually at the same time as the commitment, if we are aware that that's going to be something that's necessary. And what we have to show is that this person is not competent to decide for themselves about the medication and that they're refusing them. We cannot ask for permission to force other medications that might be helpful, which is kind of an odd thing. We can't say, court, oh, and by the way, can you also give authority to administer antidepressants. So, like the Prozacs of the world can't request authority for that, or mood stabilizers or sleep aids. Those aren't things that we can request authority for.
And I should note, a lot of times the families will call us and say, hey, as part of this commitment proceeding, will you make me guardian or make me conservator? I'd like to take care of their real estate. That's not, our office does not do that. They can pursue that. They don't have to, they can do it even if no commitment petition is ever filed. They can pursue it while we're pursuing commitment. They can pursue it afterwards. There's no bar on that. And there's a wonderful website, mincourts.gov, so mncourts.gov. And I always have to walk people through it because they keep upgrading it, so what you click on keeps changing. But anyway, under court forms, they have, Minnesota judges have put together a manual on guardianship and conservatorship, and it answers basically everything you ever wanted to know about that. You can click on it and download this manual. It's about 75 pages. They've also put all the forms for if a family member wants to bring a guardianship or conservatorship on their own. And then, of course, they can always hire an attorney to do that if they want to.
So if a person is committed and they're at the hospital, there's a few ways that a person can be let out or given, have their commitment discharged. Hospitals have the authority to grant passes. So that's a chance to leave the hospital, usually for a specific period of time. Usually there's a purpose. Usually it's supervised, sometimes it's not. But it's kind of like a trial period. How are things going to go if you leave for 12 hours today to go have lunch with your mom and go pay your bills and pay your rent or whatnot? Make sure that this person is saying, I'm going to come back to the hospital, and they really do. If those passes are going well and there's a plan to treat this person in the community, they're doing well enough to go, the next thing that happens is a provisional discharge. And it's kind of that same sort of probation-ish kind of idea where there's conditions and a case manager is going to monitor their progress with their program or whatever recommendations are made. Again, that can be revoked by the case manager, and the case manager actually has the exclusive authority to revoke that, and we're not even involved. If the person's under full commitment and they're on provisional discharge, that case manager, if they believe that the person needs to be rehospitalized and that they're out of compliance with their conditions, that case manager sends a report directly to the court, and the court issues directly an order, and we're not involved in that. Another way that a person can get out of the hospital is by direct discharge, and what that means is that the hospital itself actually can choose to end the commitment. I know there were some questions about that yesterday. The hospital, because they're named as the commitment facility, actually can say this isn't appropriate anymore. We've been treating this person for psychosis, and what we've discovered is that it was meth-induced. They're not really mentally ill. They looked very sick for a period of time, but now that they're out of this psychosis that we've now learned was because that they were doing meth 4 times a week, this isn't appropriate, we're done with this, and it ends it. There's no provisional discharge. They're not under court supervision anymore.
Them to another facility
if it's
a shelter type?
If they're not, say let's pretend that this person is committed only as mentally ill and the providers never knew that they were doing all this meth, so it was they were never committed as chemically dependent. No, they couldn't. If they thought it was a combination of mental illness and chemical dependency, they could say, as a condition of your provisional discharge, you need to get some outpatient chemical dependency treatment. But they can't force them to go into CD treatment unless we have filed a petition as chemically dependent.
That's more of the protection.
More of the protections, yep.
And of course, there are some people who have done enough meth that they have permanent brain damage, and they actually are mentally ill permanently, but it's different with different people. And there are people who, just basically get all better once they've been off it for enough period of time. And so if the hospital actually, say the commitment was to the Commissioner of Human Services and Fairview University Hospital, if the person is still at Fairview University and they think, this whole psychotic episode is completely over with, then Fairview could choose to directly discharge, like she said, or it might be something where it takes longer, the person goes to Anoka Metro Regional Treatment Center, and 4 months later, they say, okay, we have determined that a direct discharge, just ending all court authority, is a good idea. Then they can do that because they're the Commissioner of Human Services. They're speaking for them.
Pat also, well, go ahead.
So who then decides whether it's a chemical petition or if it's like a mental health one? Is that the petitioner?
Yeah,
or is that your office?
Way back at the beginning, you remember how I said that there had to be a doctor who was willing to sign a form? It's that
They need to make
doctor.
that decision?
Yep.
Okay.
Yep,
Yeah.
it's that doctor saying, this is the diagnosis and this is the treatment that they need.
Okay.
And sometimes they'll say it's both, and by the time we're in court, the experts are saying, yeah, there's both. One may have caused the other, but they're so intertwined now that, you know, we don't know. Or sometimes as things go along, they end up dropping one and saying, really, all the danger in this person's life is coming from the mental illness. Yes, they're chemically dependent, but there's not really any danger coming from that. It's the mental illness. So sometimes one petition or the other is dropped.
Okay.
Well, could it change too? So let's say the doctor was saying, okay, it's strictly, you know, mental illness. So, and then while you guys are going to the court, you do find out, okay, it does also have to do with chemical dependency too. Can you add in the chemical dependency then? Or do you have to go strictly of what the doctor has filled out?
We can request to amend the petition. Usually we ask for the defense attorney's permission to do that. Usually most of the defense attorneys that we work with, they want us to be seeking the right thing, and most of the respondents that we work with as well is they want treatment for their real problem. And if so, they discover later that it is a chemical dependency problem, and the defense attorney is saying, well, my client keeps telling me that this is because of drugs. They'll just agree that we can amend it and change it. Occasionally, we will have to have it screened by pre-petition screening and kind of start over, but we'll do it on an expedited basis so that we don't have to get another court psychologist appointed and change it up that way.
And have you guys talked about that the lawyer is with the patient the entire time?
Right, and that is a good point. The last bullet point here is the patient can ask for a hearing that the court and the commitment at any time during the course of their commitment. And so that lawyer is actually, that was originally appointed to represent them, is their attorney for the entire time that that court order is in effect. And it doesn't matter what kind of court order, whether it's a full commitment or whether it's even a continuance for dismissal. That lawyer is their lawyer the entire time.
And Andrea, can I ask, what if the patient isn't happy with their lawyer, the one that is appointed for them, and they don't have the resources to pay for their own lawyer? Can they ask for that lawyer to be discharged and a new lawyer appointed for them? And if so, how often does that happen?
It does happen. Our court entertains the request, but they won't necessarily grant it. It kind of depends on the timeliness of the request and the reason for the request. And so what I've typically seen is if it's the morning of trial, often our court will deny the request and say, you've had 6 days to make this request and have not done so, and now is our time for trial. And the way that Minnesota state law is a person has to be represented. They can't appear pro se, so they can't just show up and say, I'm going to represent myself the way that they can in criminal court. Other times the court will look at the nature of the conflict between the person, and as you might imagine, a person who has a serious mental health problem might have symptoms of paranoia or persecution, and if that is really what is driving the problem in the relationship, it's not going to matter who the court appoints for this person. If it's gotten to the point, though, that these two people truly cannot work together, our court likely would appoint a new attorney. What they'll usually tell this person is, this is it, though. Don't you come back here in 2 days and tell me that this person isn't good enough either. You get what you get now.
You have about 5 minutes left.
So we're pretty close to finishing here. I was going to say, Pat made a good point about direct discharge the other day, which is one of the, because people had a lot of questions about this yesterday. The other time that it really comes up for us is when a person isn't from Minnesota, because we can't exercise our commitment jurisdiction over people who are outside of Minnesota. So if mom is calling you saying, my son is in Florida, he took a Greyhound there, how do I get him back to get him treatment? You don't. We don't have that authority. And in fact, if, say, mom and son live in Florida and son decides to hop the hound to Minnesota and ends up here, we can commit him here. But once it's time to go and he wants to go home, we're not going to monitor him in Florida. We're just going to say we're going to end the commitment. It's going to be done.
And that usually comes up because the hospital has found this responsible relative in Florida and has been talking to them, and there's a discharge plan where the person comes here, they walk in, show ID, I really am the mom you've been talking to on the phone, the patient is agreeing to go with mom, and then as they leave Minnesota, our clients tell us, run to court quick and end this commitment because we don't want to be responsible for this person when they're in another state where we can't help them. But so it's usually part of a pretty stately exit that the hospital tries to set up to make it as safe as possible.
We talked about case management. There's different levels of case management. I talked about the one level. There are, for people who have need a lot more support, some case managers actually can meet with patients as often as 6 times a week, in which case they have a whole team of people checking on them, helping them with their medications. If the person at the end of that 6 months appears to need some additional support and treatment, we can ask that the court extend the commitment order, and we can ask for that extension to be up to a year, and it requires another hearing for us to come back to court.
And they still have a lawyer to represent them who they now know very well,
So we're going to talk about just some of your options on who you can refer these folks to, who are calling you for assistance with their family members. 911 for all emergencies, and if you question whether it's an emergency, it's an emergency. Mm-hmm. So the advice is to call 911. If it seems like something that is more of a lingering problem that needs to be assessed, it's one of those psychiatric crisis lines if it's a psychiatric issue. It's a lot more difficult if it's a chemical dependency issue and it's something that's kind of lingering and there's not an immediate emergency. Family and friends can take the person to the hospital themselves or try to get them to a doctor or an eating disorder program or to a Rule 25 assessment. NAMI has a lot of information in their handbook about different places that you could go for those things to happen. Every county has a Health and Human Services department that can help with voluntary requests for case management services or other mental health referrals. Hennepin County has a program called Project Child, which tries to voluntarily work with pregnant women who are using. I would say it's a tiny percentage of the women that they're not able to, and they will initiate commitment if that's appropriate. And adult protection also can take anonymous reports of adults that people are concerned about. They will investigate, especially if the vulnerability is coming from a mental health problem. And they will try to give this person and arrange voluntary services, but if that's not working, again, they will initiate petition if that's appropriate. The Senior Linkage Line is another resource for family members who are concerned about their aging relatives or friends, and that is another resource to help coordinate services for people to stay in the community. And of course, we've talked about NAMI. They have support groups for family members. They have mental health resources. They can help understand even the commitment process. They have a whole handbook about the commitment process as well. And so your staff had forwarded us a couple of examples. This one is about somebody who's calling about their son. He seems to be making terrible choices, and he might have some kind of mental illness and might be using drugs. How do I get him help? That son needs to be assessed, and your advice is to try to get him to be assessed. I don't know what terrible choices are necessarily, but if they're bad choices about, say, choosing not to go to college or choosing to hold a job that's well below that person's skills, those are things we can commit for, even if that person is mentally ill. There's that balance between liberty and public safety, and what our state has decided is that people can be very mentally ill, people can be very addicted, and as long as they're not hurting themselves or anybody else, they can make whatever choices. Even if I would decide that that would be a marginal lifestyle, that is up to them, and they are free to make whatever choices that way. And so I have no doubt that that's very painful for a parent to watch, and that's nothing, no parent wants to watch their child make bad choices, but we don't commit them for that.
And if they're making bad choices that do have physical danger, but it's things like DWI or assaulting other people, and it's got to do with the drug use, the criminal system is the consequences that they need to get, and in the criminal system they will still get a Rule 25 evaluation if it seems that drugs or alcohol are involved, to try and set up funding for chemical dependency treatment and figure out what kind of chemical dependency treatment they need, and the criminal court can order that too. They need to, experience, the consequences of their actions and stuff, and a lot of what Al-Anon does, which is a fantastic resource for families, is help them figure out, how can I be supportive and loving and help this person, but at the same time not be enabling and just drag the pain out. And that's what NAMI does when the problem is mental illness. And a lot of times a person really needs both.
The second example is a similar situation, except more focused on chemical use, where a mom calls and says, my daughter's dropped out of college, she won't look for work, she's had jobs but lost them because she won't show up to work intoxicated, her drinking is a problem, I think she needs treatment but she won't listen to me, is there any way for a judge to order her into treatment? Again, it comes down to harm, and there's a lot of things that need to happen before that. I mean, she really needs to be assessed. And so, I think you could best serve this caller by saying, I think the first step is to get her assessed. And if calling 911 isn't appropriate, if she's not that ill, again, maybe the referral is to a place like Al-Anon to say, you need to talk to other people about how you should be handling this, because at some point, unfortunately, the parent may just have to make the very hard choice to say, I can't support this situation anymore, and these are going to have to be the consequences. Even though that's a horrible decision to make, but the referral would be to Al-Anon so that this person could have some guidance in making those decisions.
Yeah. And the main thing is, how do you get them assessed? A lot of people are able to cajole the person into the car and get them to the emergency room, or get them to a Rule 25 assessor or something like that. And that's one route to go if there is no way they would ever get in a car with you because they have no intention of getting near a medical professional, but they pop up in the emergency room periodically. That's when you need to get to the hospital, get on the phone with your notebook, and please assess them. Please assess them for treatment, please assess them for commitment, and here's all the information I have. So you need to get them to the assessor and get the information to the people who can assess them.
And on that note, we have run out of time. So everyone, I think that we've had a phenomenal presentation. And please join me in thanking Andrea and Pat for their time today.
Thanks for letting us come.
And that brings to an end our training on civil commitments in Minnesota. As I said at the beginning of this training video, Call for Justice is a small Minnesota nonprofit that works to connect low-income and moderate-income people with civil legal resources. We are a donor-based organization. If you believe that this training video and training materials and other training materials that we have on our website are of value, we ask that you contribute and donate to Call for Justice. There is a Donate Now button on our website. In addition, we have our contact information on our website where we would love to hear from you. And anyone who does donate becomes a friend of justice and you get your own very individualized certificate from Call for Justice about being a friend. Again, we thank you. This is the end of our training program, and good evening, afternoon.